Good afternoon. Today is April the 14th of 2023, and the current time is 1 o'clock p.m. This proceeding is being held in room 310 of the Governor Office Building, as well as electronically via WebEx. The Commission has set aside this time today for an on-the-record presentation concerning the stipulation and agreement in file number ER-2022-0337, which is captioned as in the matter of Union Electric Company doing business as Ameren, Missouri's tariffs to adjust its revenues for electric service. My name is John Clark. I'm the regulatory law judge presiding over this proceeding today. Also present in person is the chairman of the commission, Scott Roop. And on the phone, I know at this point, we have Commissioners Holzman and Kolkmeyer at this point. At this time, I'm going to ask counsel for the parties to enter their appearance for the record, starting with Ameren, Missouri.
Thank you, Your Honor. Jim Lowry, JBL Law, LLC, 9020 South Berry Road, Columbia, Missouri, 65201, appearing on behalf of Ameren, Missouri.
Thank you very much. On behalf of the staff, I'm sorry, go ahead.
Wendy Tatro on behalf of Ameren, Missouri.
On behalf of the staff of the commission.
Yes, Judge. Appearing on behalf of the staff of the Public Service Commission, Jeff Keevil, given my information to the court reporter 2 days ago, I guess. And I also, we have several staff witnesses here available for questioning. Thank you.
Thank you very much. On behalf of the Office of the Public Counsel.
Nathan Williams, appearing on behalf of the Public Counsel and the public.
Consumers Council of Missouri requested to be excused, but indicated they did not oppose the stipulation and agreement and are in fact a signatory to it. MIEC, Missouri Industrial Energy Consumers.
Thank you. Diana Plesha, the law firm of Curtis Hines, Garrett, and O'Keefe, Your Honor.
Thank you. MECG, the Midwest Energy Consumers Group.
Tim Opitz for MECG.
Renew Missouri.
Thank you. Andrew Linares for Renew Missouri here.
Thank you. Counsel for the Sierra Club, the NAACP, and the Metropolitan Congregations United requested to be excused from this presentation, and that was granted. Are there any preliminary matters that the Commission needs to take up at this time before we go into the stipulation and agreement?
I don't know of any, Your Honor. I don't know if you want us to give a brief overview or you just want to go right to questions, which is perfectly fine with us as well, whatever the bench desires.
Okay, thank you. Well, this is a stipulation and agreement that purports to solve the revenue requirement issues between the parties. The signatories to this are Ameren, Missouri, the staff of the Public Service Commission, the Office of the Public Counsel, Missouri Industrial Energy Consumers, Midwest Energy Consumers Group, the Consumer Council of Missouri, counsel for the remaining parties, the Sierra Club, the Missouri NAACP, Metropolitan Congregations United, and Renew Missouri. In this stipulation, authorize the signatories to state that they do not oppose this stipulation. Because this is not like an evidentiary hearing, there's no set order of openings or anything like that. So I'm going to ask which one of the parties would like to start to give an overview and explanation of the stipulation and agreement.
I'm happy to, if Mr. Keevil, if that's okay with you.
You're the one who brought it up, so you must want to.
My Bowles will do it. I must do. So this stipulation agreement, it resolves all of the issues in the case except those that were heard this week, which were essentially, as I recall, rate design, class cost of service, an issue involving the continuing property record, and then the Sierra Club issues that they raised. But it resolves all other issues. And most of those are issues that would affect the revenue requirement, but there were some other issues as well, low-income programs and some other programmatic kinds of things, customer service that it addresses. It calls for a $140 million rate increase on an annual basis. That's just over 5% overall. I would say the stipulation in many ways is quite similar to the stipulation that resolved the company's last rate review. There are a couple of new things, and I'll just mention them very briefly. There is an Inflation Reduction Act tracker that has been agreed upon that's going to track the production tax credits or investment tax credits provided for by the IRA as and when they're actually utilized by the company to offset tax liability. There's also a property tax tracker that's been adopted, and the amount to be amortized is based on the deferrals the company began to make last September, so that's been added. The company's agreed to, essentially from a fuel adjustment clause perspective, it will continue as it has with the same sharing, with the same reporting and data retention and access requirements that we've agreed to and had in place for some time. We're also going to provide some additional locational marginal pricing data that I think Public Counsel is the one that sponsored the position in some of our monthly reports. And we're going to clean up some FAC tariff sheets that probably shouldn't have still been on the books, but what we have to do with those is we have different accumulation periods and recovery periods, and they sort of overlap, and so you have some different sheets out there at different times to make sure that until those are all have run their course, they are still available for inspection by the public, and we've got a couple of those we need to clean up, so we've agreed with the parties that we're going to get those cleaned up. We've agreed to have some meetings with the staff and OPC on some topics that were brought up, just to have some greater collaboration and information sharing on those. From a low-income program perspective, this is, I think things are continuing generally the status quo. There is a small increase in the overall keeping current and keeping cool budget from $4.4 million to $4.25 million annually. That increase is split between customers and the company 50-50, just like the rest. And there are some programmatic tweaks, I would call them, that have been agreed upon that I don't think were controversial, that have been agreed upon. Beyond that, again, I mentioned just some customer service collaboration and reporting that we've agreed upon. Beyond that, I don't think there's anything remarkable about the stipulation. The company also has a couple of folks here, in addition to Ms. Tatro and I, to answer questions if there are some. I think the two folks we have with us, Mr. Wills and Mr. Lansford, will be knowledgeable on any of those topics that I can't answer, you need to go a deeper dive into. So with that, I think we're probably all prepared to answer your questions.
I'm going to go ahead and ask a couple questions now rather than let everybody go through because I'm just going to do it that way. I guess, can you give me, we've had a lot of rate cases and there's a lot of testimony flowing through my head. Can you just remind me the rehousing program, what it does?
I probably can't, but I suspect Mr. Wills can, perhaps.
I can start in on it, and probably Dr. Mark can weigh in also, because I think that's something the OPC proposed in our last case, and it's continuing, but I'll give it a high level, and if that's not good enough.
High level is great.
Yeah.
Just refresh me here.
So the rehousing program is about folks who are trying to establish service after some period of either homelessness or being in a shelter or something like that, and it will help them overcome like past utility bad debts and things like that.
Okay, that was it. And then the critical needs program. How does just run me through those again.
And again, I may look at Dr. Mark if we get too far into it, because again, this is one that we worked with him on setting up. But the critical needs is about, I think, connecting customers to different agencies and services to help with folks who have either medical issues. It provides, and I think we work in collaboration with the United Way and other utilities to put together a means for customers to access multiple forms of assistance and services and information.
And is this the one where you work with like the NECAC and those to get the low income or the energy assistance program information out? Is that the one that runs through here?
I think this is the one that has both Spire and, is it Evergy? Who's the other one?
Spire is involved. Dr. Mark is gonna help us out. He's gonna come save the day.
Mr. Keevil, can you speak into the microphone when you talk, just so it picks up?
The Critical Needs Program is a collaborative program that now incorporates all of our utilities, I think with the exception of Summit today, because they haven't been in for a rate case. It went live earlier this month. It's been a 1-year effort, so it's taken about a year to get to that point. It's a all access on, no off ramps is effectively how it's been characterized. The United Way's running it. If a customer that's in medical needs is identified at, say, at BJC for hospital, they're serviced with a social service worker. At that point of entry, as their information gets collected and put in, it's also forwarded to a byproduct of the 211 program with United Way. At that point, it's then filtered out to the utilities themselves. So if that customer is eligible for utility assistance, they're allotted that. It's a way to streamline the process and to bridge the gap over bureaucratic red tape is the long short of it. We are planning on doing sometime this summer a presentation from the United Way in front of the commission. So
Okay. All right, great. And then the only other question I had on that section was, what is the weatherization program budget now? And I know it's going to 1.2 million. Is that the same? Is there?
It's the same,
Yeah.
yeah.
It's the same.
And the critical needs and rehousing, and Jeff will correct me if I'm wrong, it arose in our last rate review, I believe. So
Okay.
it's been in place, well, that was February of '22, so we're a little over a year into it.
Okay, great. And the only other question I had was in the, it's not for you, Dr. Mark.
Okay.
It was brought up today in the other hearing, that there was an agreement on Rush Island inside here. Can you just give me a brief?
No. What I was intending to say is the revenue requirement, the Rush Island issue, all the parties we're not asking for any further ruling on the Rush Island issue in this case.
Okay,
So the revenue requirement reflects whatever the parties think,
okay.
right, as a black box.
All right, thank you. That's all I had right now, Judge. Thanks.
Thank you, Chairman. Do any other commissioners have questions regarding the stipulation and agreement?
Not at this time, Judge. Commissioner Holzman.
Thank you, Commissioner Holzman.
Commissioner Kochmeyer and I have no questions. Thank you.
Thank you, Commissioner Kolkmeyer. I'm going to ask what may be a stupid question, but I'm going to ask it anyway.
No such thing, Judge.
Wait and see. In regard to Exhibit A, which is the billing determinants that was attached to that, there's nothing in there that would, and if you remember from the hearing, class cost of service and allocation was an issue that is to be determined by the commission. Is there anything in those billing determinants that would anyway hamstring the commission in terms of doing an allocation that they would like?
I'm sure the answer is no, but I'm going to ask Mr. Wills to more specifically address your question.
Mr. Lowry's correct. There's nothing in there that would have any bear. This just tells us what we're going to use to calculate rates, but you'll tell us how much revenue to put into each class to divide over these numbers to calculate the rates, right? So we need, we need to have the revenue requirement that we've agreed to divided into class responsibilities. And when we have those revenue dollars by class, there'll be you'll divide dollars by kilowatt hours and other metrics in here to come up with the rates, but these tell us what the divisor of that calculation and the rate is.
Thank you very much. That was my assumption, but I just wanted to be sure because I didn't want it to affect that issue. I don't have any other questions other than as a curiosity, this is a black box settlement. Is there anything you can tell us about the black box settlement that's not already in the stipulation and agreement?
I wouldn't say this is really telling you anything about the black box settlement, but as Mr. Lowry indicated, it does provide for a revenue requirement increase, approximately 140 million, I believe it is. It's interesting, or might be interesting, to go back and look at what the parties' filed positions were prior to the settlement. And I think the last Ameren position was about 230 million. And staff's was about 107 million. So the 140 is I guess you could say in some ways closer to staff, but it's a nice in-between sort of number that I think everyone supports.
The company was about 240. Our final was 240, is where we were.
Is that your way of saying staff one?
No, I wouldn't say, I would not say staff one, because like I said, there's lots of things in here, and I think it's a well-balanced stipulation, because, you know, there's give and take on lots of issues, and like I said, it's I think a fairly well-rounded stipulation, let me say.
The only thing I'd add is if you do look at where the different parties were as time progressed through the case, if you look at the testimony, direct versus rebuttal, surrebuttal, true-up redirect, and true-up rebuttal, you'll see quite a bit of movement in each party's position in terms of what the revenue requirement should be.
Judge, I have a question. I did have a question on the LMP data that was requested by your office. Can you speak to that and the importance of what additionally you're going to be getting from the company and what your plans are on using that for?
I don't know if Lena Mannel's available or not, but I don't know exactly why we were requesting that data. I'm sure it has to do with, well, I believe it has to do with prices for doing analyses, but beyond that, I can't tell you more specifically.
Pardon me, Nathan. Mr. Chairman, I can't, I guess, completely answer your question, but I will say the data that we are going to give them, it is publicly available from MISO, but we have a tool that when we pull that data down, we can sort it in a way that OPC could do that, but we do it anyway, and so
Okay.
I think we're sort of what they exactly are going to do with it, or I don't know, but I think we're helping them out by sharing that sorted data that they could have sorted, but we do it we do it because that facilitates our settlement process.
All right.
I
That's
think it's for obtaining some more granular information than we're getting otherwise from the utility, but I'm not disputing what Mr. Lowry's saying because I don't know to dispute it.
We had a lot of discussion on granular data in our other hearings, so that's a positive thing, right?
I will say that it's not really required, other than we have to add it to a report that we already file. It's really not requiring time, effort, money to do it on our part. And it is data that they would get in rate reviews or fuel adjustment clause, periodic adjustments anyway. So I think we're just facilitating them having it.
Very good. Thank you.
Any other commissioner questions at this point? I have no further questions. Is there anything that any of the signatory parties wanted to say? I'm hearing and seeing nothing.
I'm just going to say don't forget the exhibits.
Thank you for reminding me. And I assume everybody bought their exhibit list because we're going to need that to go through this somewhat exhaustively. Well, I guess the only thing I can say at this point is we are done with the substance of this rate presentation. So I don't know if the commission wants to stick around to watch me exhaustively enter exhibits into the hearing record, but that is what I'm going to be doing for, say, the next 30 minutes or so.
Judge, this is Commissioner Holzman. Just want to say thank you and thank everybody for all the hard work on this case.
Thank you very much, Commissioner Holzman.
Yes, this is Commissioner Kochmeyer. I will echo those same thanks to you and all the parties involved here to come to a good decision here on this case. So thanks, everyone.
Thank you, Commissioner Kolkmeyer. I have no formal way I want to do this, so I'm just going to start with the parties. So why don't, which party do I want to start with? Do I just want to go in the order that the parties would normally do their entry of appearances in?
Go in the order that you assigned the exhibit numbers in, Judge, with Ameren, I think, had the first batch, and then staff, and then
I very much like that idea, Mr. Keeble. Let me pull up my, procedural schedule. Or did I? No, I sent those out to the parties via email, didn't I?
Yes. Ameren is first, Judge. We start with number one.
Yes, but I can't type and write at the same time.
Judge, I'm aware that public counsel, and I believe most, if not all, the other parties provided you with exhibit lists already. Do you want us to step through each exhibit or just refer to the list?
Hold on just a second and I'll try and answer that. I'm still trying to find something. Okay, there's my email. Now, I'm assuming right now that all of the exhibits that the parties are asking to enter into this on the record, in this case, are filed in EFIS, and that nobody's brought any paper copies of anything that's not contained in the exhibit list. I have no problem doing these in batch if we want to do it that way, as long as the parties feel that's sufficient to protect their interests. I guess I'll ask this way. Ameren, Missouri, are there any exhibits on your list that are not being entered into the record for this?
They are not.
Okay, so everything, including what was entered in the, everything including what has been entered into evidence in the evidentiary hearing?
Everything, yes.
Okay, and that would be my assumption. Okay, so
So I think that makes a total of 51 pieces of pre-filed testimony.
I've got 51 pieces of pre-filed testimony and one additional exhibit, 52C.
Yeah, and of course, some of those have confidential and public versions, but same testimony.
Okay. Are there any objections to entering exhibits 1 through 52C onto the record for this on-the-record presentation?
Your Honor, just for the sake of the record, perhaps our exhibits 32 through 52 have already been admitted to the record according to our records at least. And so maybe just for clarity, I think we would be moving 1 through 31 into the record at this point.
Okay, so you want to treat this as a single, even though it's multiple proceedings, you want to treat it as a single record, is that correct?
I think the case is a single record.
That would make sense.
Yeah, Judge, we're wanting to admit the exhibits into evidence in the case so that
Okay.
it is evidence for the commission's consideration.
And that works for me, and that explains your little squint when I said that.
Yeah, the stipulation, Judge, I don't know if you may have noticed, but it specifically provides that we've agreed that all of that testimony will come in, and of course, that's also helpful to the commission because it provides them an evidentiary basis upon which to approve the stipulation.
Thank you very much. Okay, let's do that then. So, is there any objection to admitting exhibits, is it 1 through 31? On to the case record? I see no objections. Ameren's exhibits 1 through 31 are admitted onto their record for this case. Next, I have staff.
Judge, before we leave, just out of curiosity, what was 52C? With that, I think Ms. Petro had a special remark about that one.
That was the company response to DR-591.
Oh, okay, so that was one of the exhibits
That was a
entered
hearing
during
exhibit.
the hearing.
Yeah,
Okay.
that was not a pre-filed.
Okay, that explains that. Thank you.
Judge, one other thing, just for the sake of the record, I'm wondering if you should order us or ask us to submit these exhibit lists into EFIS, because they have the identifier of the, the witness tied to the exhibit number, and that way the record will be clear as to what 1 through 31, for example, were. Because you haven't verbally gone through that on the transcript of every witness's name, but you could short circuit that by having us submit the list into EFIS.
I appreciate all the help and suggestions I can get at this point, so I will be happy to do that. So,
And that would also, I think, reflect public confidential and in
It would.
a few limited respects, highly confidential, because we did have to have one filed as highly confidential. So if we do file the list, each party can show for each piece of testimony, whether it's PC or HC.
Okay, well, is it enough for me to verbally order that, or would you like me to issue a written order?
I think an on-the-record order is just as much of an order from my perspective.
Yeah,
Okay,
works
I
for me.
will order the parties to file in EFIS their exhibits list as to the exhibits that are being admitted onto the hearing record for this case,
Good.
ER-2022-0337. And
Well, now what you just said would include ones that were introduced during the testimony part of the hearing that we had the last couple of days. I was thinking that I was expecting what you were to say was just be for the pre-filed exhibits.
for the pre-filed exhibits, I'm going to order the parties.
Exhibit list to be filed for the pre-filed exhibits.
I'd say it's slightly differently, Mr. Keevil. I agree with the general concept. I think we all should file a list, and we should state that this is the list of exhibits that were admitted on the record on whatever today is, April 14th, 2023, during the on the record. And that way it'll match up to the transcript in terms of exactly what was admitted and what those documents were.
Yeah, as long as it doesn't have to include the exhibits that were introduced during the live hearing.
Right, I agree. That's why I said during the on the record.
During the present, okay.
We should delineate that when we submit the list, that this was the list of exhibits corresponding to the numbers that were admitted by the judge during the on the record presentation.
That makes sense. Let's do that. So to clarify, and if I say this wrong, let me know. I'm going to order the parties to submit the exhibit list as to the exhibits that were admitted onto the record at the on-the-record presentation. Is there any party that believes that's not sufficient? Okay, let's move on to staff's exhibits.
Yes, Judge, we had the 100 block.
And
So-
I've got 100 through 116.
Right, 100 through 116, some of which are P, some of which are C, and some of which may be HC. And then 117, 118, and 119 have already been received, as you noted there. So we would pick up again at 120 and go through 135. And then 136, 137, and 138 have already been received. So we pick up again at 139 and go through, I believe the end of the list is 177. And again, some of those will have public, some of those will have confidential, and one or two of them has highly confidential. And when I submit the list, the list will indicate which has public, confidential, and highly confidential.
Okay, thank you. Any objections to admitting staff exhibits 100 through 116 onto the hearing record, or onto the case record? Staff exhibits 120 through 135, and staff exhibits 139 through to 177. Are there any objections to admitting those onto the hearing record? Those are so admitted. Next, I have public counsel. It looks like 200 and 201 have already been submitted onto the hearing record, so we're looking at 202 through 211. Is that correct?
Yes, public counsel offers exhibits 202 through 211 into the evidentiary record in this case.
Is there any objection to admitting exhibits 202 through 211 onto the case record? Those are so admitted. Bear with me for just a moment. Okay, I do not have an exhibit list from Consumers Council of Missouri. I know that they had some exhibits entered onto the hearing, or already have entered. They were signed 3 through 349. I believe they only had 2.
I don't believe they have any other witnesses, Your Honor.
And I believe that would be the Exhibit 300 and 301, which are the
Probably Jackie Hutchinson's testimony.
that is correct, and that has been admitted onto the hearing record. Okay, so nothing further on behalf of Consumers Council. Missouri Industrial Energy Consumers Group.
Missouri Industrial Energy Consumers Group has had admitted into the record 4 exhibits, and those are marked 315.
Those all Brubaker testimony.
Correct. Well, the last one is actually the settlement schedule.
Right.
And those have already been admitted onto the hearing record. Do you have any additional exhibits that need to be admitted as part of this proceeding?
No, we do not.
Okay, thank you very much. Moving on to Midwest Energy Consumers Group.
Thank you, Judge. 400 and 401 were admitted this morning, so I'll move 402, public and confidential, and 403 into the record. And that's
Thank you.
the testimonies of Greg Meyer.
Any objection to admitting MECG exhibits 402 through 403 onto the hearing record? See none, those are so admitted. Renew Missouri had 1 exhibit, Exhibit 450, the rebuttal testimony of James Owen, that has already been admitted onto the record of this case. Renew, do you have any other exhibits that I've missed? I hear nothing. Bear with me just a moment. Sierra Club, I believe, had the testimony of Tyler Cummings. And that was Exhibit 500, his direct testimony, and that has already been admitted onto the record of this case. With that, I believe that admits all of the outstanding exhibits that have not been admitted, that were admitted on the record just minutes ago, and were also admitted by agreement of the parties in their stipulation and agreement. And I would ask how much time do the parties need to file those exhibit lists?
Monday?
Let's do it Monday or Tuesday. I'm going to have to delete part of my list, and so if you have it Tuesday.
Okay. My previous order to file an exhibit list as to the outstanding exhibits that were admitted in the on-the-record presentation. Those lists are due to be filed in EFIS no later than Tuesday, April 18th. Is there anything else that the commission needs to take up at this time? Okay. I hear nothing. With that, we will adjourn this proceeding and go off the record. Thank you very much.